My name is Michael Perutka. Remember me? I was the guy who was here for your first lesson. Are you going to do an intro? Are we streaming yet?
Are we up on this one, Rob? Or not?
All right, go ahead.
Am I on the microphone?
There
Okay,
you go.
great. Well, thank you so much for joining us this evening for Institute on the Constitution's webcast, Constitution course, and for all the students that are here in our classroom, welcome. We are getting close to being done. Lectures 8 and 9 tonight. We're going to be covering a variety of different topics. Michael will be your first instructor, and then David will pick up on Lecture 9. Just a reminder that next week is Lecture 10 and 11, and then the following Monday is graduation. We're going to be doing our LAG course, which talks about local advocacy, how you can take this material that you've learned, this knowledge that you've learned, and apply it into your local government, which is a great place to start. Many of you know Michael Perutka is actually running for county councilor, and so this is a great way, a segue, if you will, into that next world. And there's by far much more materials that we have available for you as you enter into this journey. Now, a lot of people struggle with the concept, well, there's nobody good to vote for. And as Michael says quite often, maybe that means you're looking at him when you look in the mirror. Maybe that's who needs to run. You could be that next person. We just got back from a great tour in Ohio, so thank you to all of you that are in Ohio, those of you watching. We had a phenomenal week out there, a lot of new people, and a lot of new folks that are interested in starting even campus clubs, so bringing our material into high schools and also into potentially colleges and grade schools. As you all know, and this is my last plug, I promise, before I hand it over to Michael, Saturday, October 18th, Dr. Ken Ham is going to be joining us, so I want to give you a last opportunity. Our introductory ticket prices are ending this week, so please register. If you haven't registered yet, you're not going to want to miss this event. It's going to be phenomenal. So with that, I'd like to introduce Mr. Michael Anthony Perutka for Lecture 8.
Thank you very much, Jake, and good evening again. It's great to be with you. I started out by saying, remember me, I'm the guy who was here for Lecture 1, and between then and now you've had other instructors, including Pastor David Whitney, who will be doing Lecture 9 right after me today. We've got a little late jump here, and I know we've been having some internet connection problems, so for anybody who's having difficulty or tuning in or whatever they call it now, I'm grateful for that. Please bear with us. In Lecture 8, we're going to cover the Bill of Rights and the Bill of Rights generally and the First Amendment. 2 Corinthians 3:17 says, where the Spirit of the Lord is, there is liberty. Think about that. Where the Spirit of the Lord is, there is liberty. So where the Spirit of the Lord is not, there's no liberty. So as we live in an age where we've moved from this biblical worldview to the pagan worldview, what have we been doing? Well, we've been removing the acknowledgement of God. We've been removing our connection to God's Spirit, the Holy Spirit. We've been trying to subjugate that and put it out of our minds and take it out of our government. And we have this crazy, perverse understanding of separation of church and state, which we'll talk about a little bit tonight. And as long as we keep doing that, we will not have liberty, because Psalm 9:17, as my friend John Lofton used to say, the wicked shall be turned into hell, and all nations that forget God. If we are a nation that forgets God, we will not have the Spirit of the Lord, and therefore we will not have liberty. General objectives for tonight. It's our intent and it's our hope that you're going to be able to understand the historical background of the Bill of Rights, including the arguments favoring and opposing the adoption of the first 10 amendments to the Constitution. And we desire that you're going to be able to understand the purpose and function of the First Amendment and the restrictions it places upon whom? Upon the federal government. The First Amendment places restrictions upon whom? The federal government. Okay, remember that. Keep that in mind. Hopefully we'll end with that same thought tonight. Specifically, we hope you're going to articulate the reasons why some of the framers, including James Madison of Virginia, argued that a Bill of Rights was unnecessary, and why some other framers thought it might prove dangerous to the people's liberty. We hope you're going to understand the process by which the Constitution can be legitimately amended, and appreciate the founders' concern that methodology, that amendment process, not be evaded nor abused. We hope we are going to be able to understand and articulate the true and proper understanding of separation of church and state, because there is a proper understanding, and I often say that the greatest lie ever perpetrated on the American people is separation of church and state. But in fact, what makes it a great lie is it's partly true. A great lie, in air quotes, if you will, has an element of truth in it. That's what makes it a really, really good lie. Good, of course, I don't mean good. But we're going to talk about the lie and the truth of separation of church and state. We hope you can understand and be prepared to dispel the many myths and falsehoods perpetrated by the government, schools, and by the media regarding this separation of church and state. And we hope to develop a proper framework for understanding the opinions of the Supreme Court in what are considered to be, and maybe should be in quotes too, the leading First Amendment cases and the tests that the court uses to decide First Amendment cases. You're going to find out in this lecture that we have a very low opinion of what the Supreme Court First Amendment jurisprudence, or what passes for First Amendment jurisprudence, and the misuse, if you will, or the abuse of these tests. In the First Amendment, when the Supreme Court uses tests to decide First Amendment cases rather than the actual words of the Constitution, we think there's a problem. Here's that quote from 2 Corinthians 3:17. Where the Spirit of the Lord is, there is liberty. Patrick Henry rode many miles on horseback in 1768 to a trial in Spotsylvania County, which is a beautiful place still in Virginia. He entered the rear of the courtroom where 3 Baptist ministers were being tried for having preached without the sanction of the Episcopalian Church. Now remember, they weren't being tried for preaching heresy. They're being tried for preaching without a license. That's what was going on here. In the midst of the proceedings, he interrupted, "May it please your lordship, what did I hear? Did I hear an expression that these men, whom your worships are about to try for misdemeanor, are charged with preaching the gospel of the Son of God? That's their crime?" Okay. With that as background, we're going to talk about the Bill of Rights first and then the First Amendment. Historically, Englishmen, well, not only Englishmen, but all people, but Englishmen can particularly, have occasionally thought it necessary to reassert their ancient rights. This is really the situation we find ourselves in today. We're not really trying to make up new rights and do something new here and institute on the Constitution. In fact, we're trying to do something old. We're trying to reestablish an order that has been denigrated, not unlike the English noblemen were doing in 1215 at Runnymede when they faced King John and said, "You're going to sign this Magna Carta." And the Magna Carta was a document that made King John acknowledge that there was a higher moral law above him to which he owed obedience. Sound familiar? This traces its way right to our Declaration of Independence. Also, the Englishman's Bill of Rights in 1689 reasserted the true, ancient, and indubitable rights and liberties of the people. So from time to time, the people have found it necessary to go back and restore an order that has been lost. This is why I frequently say I don't think the American Revolution was really a revolution. I think it was an American restoration of an order that had been denigrated. So I always call it the War for American Independence. I don't call it the American Revolution or the Revolutionary War because I don't really think it was a revolution. I think it was about a restoration. Why was there no Bill of Rights in the original Constitution? Excuse me. I talked about the Magna Carta and talked about the Englishman's Bill of Rights. Why was there no Bill of Rights in the original Constitution? Well, James, for a couple of reasons. Madison actually made the argument that a Bill of Rights was unnecessary. Since the federal government had only limited powers anyway, there was no need to prohibit government from doing what government had no authority to do. In other words, why should we have to say that the government can't interfere with speech when we haven't given the government the authority to interfere with speech? Why should we say that the government can't interfere with the right to bear arms when we haven't given them the right? So, in other words, the scheme of the Constitution was we're going to give them certain powers. They're limited. They're enumerated. They don't have any powers other than that. That was the idea. So Madison said, well, if that's the idea, then a Bill of Rights is really unnecessary. By the way, I think that argument was a little disingenuous. I think he knew from history that governments step out of their bounds. But he made the argument anyway. And I think this argument by Hamilton may have also been a little disingenuous. But here's the argument. A Bill of Rights could be dangerous, Hamilton said, because it could not possibly list all rights, and a future government might conclude that rights not listed were forfeited to the government. He said rights are better protected by relying upon establishing English and American common law. Suppose I asked you to go home tonight and write down all your rights. Between now and midnight, write down all your rights, and anyone that you forgot about, you wouldn't have on the morrow, right? Would you be a little worried? Would you kind of stay up all night, maybe worried that you'd forgotten to list some of your rights? Okay, well, that was Hamilton's point. He's saying if we go ahead and list rights, maybe we'll forget some. Well, that's basically what the Ninth and 10th Amendments are about. But we'll get to them in a minute to take care of this worry. But many people wanted a Bill of Rights anyway. As a matter of fact, the lack of a Bill of Rights was a principal objection of the anti-federalists, the opponents of the Constitution, such as Patrick Henry and George Mason. And then, just as a side note, I think it's interesting in my reading and my study how many times I go back to look at Patrick Henry's statements or George Mason's statements and go, man, they were right. They were right. They warned us of the dangers that this government would get out of control, and so it has. But so they argued for a Bill of Rights, and Jefferson, although he was in France at the time, he generally liked the Constitution, but he expressed the fact that he regretted the lack of a Bill of Rights. During the ratification debates, the Federalists, those were the supporters, they promised to support a Bill of Rights if the Constitution were ratified. In other words, let's get this done. If we get this done, we will support your Bill of Rights idea, okay? And they did. So in the state ratifying conventions that ratified the Constitution itself, there were about 350 proposed amendments, many of which were duplicative of each other. And Madison took these 350 and worked them into 12 amendments and introduced those 12 into Congress in 1789. As we know, of course, only 10 of those 12 passed, and that's our first 10 amendments. There were 12 that were proposed as the original Bill of Rights. So Congress, the congressional committees reworked these 12 that Madison submitted and passed 10 of them. Passed all 12 of them, but only 10 were ratified by the states. Okay, we have this little football field analogy that my colleague David Whitney came up with. So if you really like this, it was my idea. If you don't like this analogy, it was not my idea. No, I'm kidding. David suggested that if the Constitution and the legitimate functions of government are a football field, we have these chalk lines that are the boundaries of the football field. It says you can't go outside of this. If a player or the ball goes out of bounds, we stop playing, we bring it back in, and we keep the play going. But so there's boundaries to the game, just as there are boundaries to the powers of the federal government, the central government under the Constitution. Okay, but the chalk lines on the field really aren't much of a boundary. People go off them and out of them all the time. So the Bill of Rights in this analogy was really building walls. Let's say we build some concrete walls there around the field rather than just the chalk lines. Now, you can't get out of bounds. You know, this is the Bill of Rights was an idea. It's like your government, you can't do this, you can't go here, you can't go there. So it's to confine the government on this, well, in this analogy, on this field of play, right? All right, well, interestingly, and I don't want to get ahead of myself here, but interestingly, the Bill of Rights was intended to do that, to let's say, to be these concrete walls. That's the first 10 amendments. Now, how many amendments to the Constitution have we? We have 27. So the first 10 built these walls. And I think what you're going to see if we continue this analogy as we go forward and study the other amendments, that many of the other amendments broke down these walls. In other words, the first 10 amendments were limits on government power, government authority. Pretty much the next 17, well, certainly after 11 and 12, the next 15, from 13 to 27, were great expansions of government power. They had the opposite effect of the Bill of Rights. They amended the Constitution not to limit the government, but to expand its authority. And if you turn to the Constitution, in my book, I'm looking at page 103. I'm not sure what page it is on. We have a couple different versions of the book. But if you actually look at the 13th Amendment, I'm directing you to the 13th Amendment, which, again, in my book is on page 103. But if you look at that, the end of the 13th Amendment, what's listed as Section 2, is a sentence that is a very important sentence in our Constitution. And it's important, but it's really a crucial sentence. It says, Congress shall have power to enforce this article, meaning the 13th Amendment, by appropriate legislation. Now, that sentence appears in the 13th Amendment, in the 14th Amendment, in the 18th Amendment, the 19th Amendment, the 20th Amendment, I think, the 24th Amendment, and the 26th Amendment. It appears a number of times. So, while amendments to the Constitution, the Bill of Rights, sought to limit power, this sentence says Not only are we making this change, but Congress shall have the power to enforce this article by appropriate legislation. In other words, we're giving a blank check to Congress to keep the changes going, to change and change and change and change. And there's no even time limit on the amount of time that Congress can change it. So, again, in this analogy I'm using, this is like driving a tank through those concrete walls or blowing a hole through those concrete walls with these subsequent amendments. So the point here is that the early amendments did one thing, and the subsequent amendments had a very, very different effect. So the necessary 3/4 of the states ratified the first 10 amendments in 1791, and they became known as the Bill of Rights. I'm sorry, give me just a second here. I turned my page and I've got to find my page back again. 173. Thank you very much. Madison's 11th Amendment dealt with congressional reapportionment and actually was never ratified. And then Madison's 12th Amendment, I talked about those two that didn't get approved. That one had to do with congressional pay raises and did not receive much initial support, but over 200 years after it was introduced, it was finally ratified. So in 1993, so it's now the 27th Amendment. One might argue that that's an unreasonable time for them to leave the amendment process open, but there it did. They did it. Each of these first 10 amendments, as I said, limits federal power, and most of the remaining amendments, for the reasons that I just explained, expand federal power. And initially, the Bill of Rights limited. This is a very important point here. Initially, the Bill of Rights limited only the federal government. It's aimed at the central government. It's not aimed at the states. But courts have ruled something called the incorporation doctrine, the Supreme Court came up with, that ruled that the Bill of Rights are incorporated into the 14th Amendment, and thereby they apply to the states. Now, this incorporation doctrine is really another abomination, if you will, and a real perversion of the Constitution. And let me use another analogy that I've used in my mind and in some of my talks about this. If the Constitution and the Bill of Rights was meant to be the guardian of the hen house, right? It meant to be the watchdog of the hen house, to protect our rights and protect the states. Well, then once the 14th Amendment, Amendment incorporation doctrine was established by the Supreme Court, quote unquote established. Now we have the situation where the fox is now in charge of the hen house, because now the theory is that we have to keep these bad old states from abusing your rights. And who's going to keep us from doing that? Who's going to keep the states from abusing your rights? Well, of course, the federal government, who the Bill of Rights was intended to limit in the first place. So now the fox is the guardian of the hen house. And that's why this incorporation doctrine is a real perversion of the Constitution. And by the way, it's not in the Constitution anywhere. It's a Supreme Court ruling. So a Supreme Court ruling, is a Supreme Court ruling law? What does the first sentence of the Constitution say? All legislative power, that is lawmaking power, herein granted, is vested in a Congress of the United States. So do courts make law? No, but this incorporation doctrine is seen as law in our legal profession and in our courts. But now you know something that lawyers who go to University of Maryland, University of Baltimore don't know, because they're not taught. Now you know that the 14th Amendment incorporation doctrine is not law at all. All right, so that's an overview of the Bill of Rights. Let's talk about the First Amendment for a few minutes. Congress, who? Congress, who? Congress shall make no law. This doesn't talk about the states or Greece, New York, or any town council or anything. Congress shall make no law respecting an establishment of religion. Let's say religious liberty is a biblical concept, of course. In the Old Testament, there was a separation of church and state. Kings always came from the tribe of Judah, and priests always came from the tribe of Levi. So there's a true understanding of separation of church and state. They had different functions. The priests were from this tribe. They did certain things. The kings were from this tribe. They had other jurisdictions and other functions. In the New Testament, when in Matthew 22, verse 21, where Christ says, render therefore unto Caesar the things that are Caesar's. He doesn't say render to Caesar everything Caesar desires, or everything Caesar asks for, or everything Caesar demands. He says, render to Caesar what? The things that are Caesar's, indicating that Caesar's authority is a limited one. Caesar's not in charge of everything. He's in charge of some things, but not everything. All right. So the civil government derives its authority from God, and we can look at Daniel chapter 2. He changes the times and the seasons. He removes kings and raises up kings. He gives wisdom to the wise and knowledge to those who have understanding. So civil government comes from God, and again in Daniel, later on in chapter 4, it says, till you know that the Most High rules in his kingdom of men and gives it to whomever he chooses. So God superintends these things. We look at Romans 13, verses 1 to 4. And we see that it says, let every soul be subject to the governing authorities. There is no authority except from God, and the authorities that exist are appointed by God. Therefore, whoever resists the authority resists the ordinance of God, and those who resist will bring judgment on themselves. But it goes on to say, for rulers are not a terror to good works, but to evil. So if you have somebody who pretends to be a ruler, but he's not a terror to good works. Excuse me, he is a terror to good works, and he's not a terror to evildoers. Is he a ruler? You see the point? So a lot of times I think confused ministers or some confused Christians think that, well, whatever Barack Obama or whoever, Martin O'Malley, whatever they say, we have to follow because Romans 13 says so. No. Romans 13 says, do what is good and you will have praise, because it says he's God's minister to you for good. Well, if you really think that Martin O'Malley is God's minister to you for good, I got a bridge for you. But you see my point? 3 times, I think it is, in Romans 13, the civil magistrate is called God's minister. So we have to be careful who we think is a civil magistrate. Is anybody who just pretends to have a badge? If somebody just breaks in this room right now with an AR-14 and starts ordering everybody around, puts you on the floor, starts making you do things, is he God's minister to you for good? He seems to have authority for the moment, right? But does that make him God's minister? No. We have to look at his actions and what he does to see whether he's God's minister, whether he's really falls under Romans 13. So all law is based upon moral values which have their roots in religion. And again, the subject of the First Amendment is, one of the subjects of the First Amendment is religion. So we look to Rushdoony, and we carry his book here, Law and Liberty. I got to back up one here, I think. Here we go. Rushdoony, in his book Law and Liberty, says, the statement you can't legislate morality. You sometimes hear people say that, don't you? You can't legislate morality. He says this. He says, it's a dangerous half-truth and even a lie, because all legislation is concerned with morality. All legislation. It's just a question, really, usually of whose morality. You know, people say, well, you don't want to establish a theocracy. Well, in one sense, all governments are always theocracies. The just question is, who is theo, right? What's the source of authority? So he says you can't legislate morality. Is a dangerous half-truth and even a lie, because all legislation is concerned with morality. Every law in the statute books of every civil government is either an example of enacted morality or it's procedural thereto. Our laws are all moral laws, representing a system of morality. Laws against manslaughter and murder are moral laws. They echo the commandment, thou shalt not kill. Laws against theft are commandments against stealing. Slander and libel laws, perjury laws, enact the moral requirement, thou shalt not bear false witness. You see? So traffic laws even are moral laws. Their purpose is to protect life and property. Again, they reflect the 10 Commandments. Laws concerning the police and court procedures have a moral purpose also, to further justice and protect law and order. Every law in the statute books is concerned with morality or with the procedures or the enforcement of law. And then this final sentence, which he says, because all law is simply enacted morality. He says it's impossible to have law without having morality behind that law, because all law is simply enacted morality. You see that? So to say that you can't legislate morality really is not true. You're always legislating somebody's morality. The question is whose? Are we legislating this biblical view on which our country was founded, or are we legislating some pagan view? That's really the question. Again, it's either theonomy or autonomy. It's either we're always legislating morality. The question is, which morality? Whose morality? Are we legislating the morality that 9 guys on the Supreme Court, nine former attorneys, or current attorneys, I guess, make up, or something more eternal? The colonial charters acknowledged God as the source of government authorities, and many colonies had churches already, and of course, when they became states, had state churches. The New England colonies were mostly congregational, in Massachusetts, Connecticut, New Hampshire. The southern colonies were mostly Episcopal. Some of the middle colonies were mixed. They had greater degree of religious freedom, but still publicly recognized God and often required citizens to affirm Trinitarian faith to vote and hold office. So the point here is there already were established religions in the states that the states were supporting in one way or another, right? So between 1620 and 1789, the American climate moved toward religious liberty, really for several reasons. The writings of John Bunyan and John Milton, for one thing, the Puritan thinkers. The occurrence of the First Great Awakening, which was a Christian revival of the 1740s, led many to leave the established Church of England and to join what were called some of the dissenting churches, Presbyterian, Methodist, and Baptist. And they then objected to supporting the Church of England in those states. So Madison and Patrick Henry and others defended the Baptists accused of preaching without Episcopal ordination, and this led them to press for religious liberty in Virginia. Concern over England's alleged attempt to install an archbishop over the colonies. This was an issue. They thought that England was going to try to establish an archbishop, and maybe the most important was, we've already alluded to this, which church would be the established church of the United States. See, you already had established churches in the different states, and that led to an agreement at the Constitutional Convention that there wouldn't be any established from the federal standpoint. There are already some states that establish churches. We're not going to establish. Any establishment of a church will be a state matter, not a federal matter. But it's important to understand what the meaning of the Establishment Clause means. This idea of wall of separation between church and state, of course, I'm sure you know, that there's no phrase separation of church and state in the First Amendment. I hope you know that. If you don't, you know it now, right? The word separation isn't in the First Amendment. The word church isn't in the First Amendment. The word state isn't in the First Amendment. The word of, I will grant you, is in there 5 times. I counted it. But separation of church and state, that phrase, is not in that document or any relevant document. Jefferson penned the words in 1803. 14 years after the First Amendment was already adopted. And by the way, he was in France when the First Amendment was adopted. And in that document, there it is. So he had no direct hand in it. Jefferson saw the wall of separation as something that protected the church from the state. When the Danbury Baptists wrote to Jefferson, and by the way, both of these letters are in your book, their letter to him and his letter back to them. When they wrote to him, basically he had just won re-election, and this was kind of like a fan letter they were writing to him. They were, but they expressed this concern that they didn't want to be. They were worried that the state might, the federal government might involve itself in their religious matters. He wrote back saying, "No, don't worry about that. We've established a wall of separation," but his wall of separation didn't mean that the church couldn't affect the state. It said the state wouldn't affect the church. It was a one-way wall that protected the church. Now we've got this exactly opposite meaning of it that's come through what some call Supreme Court jurisprudence of the First Amendment, and I kind of mockingly call it that. So Jefferson's words in that letter, virtually forgotten for 150 years, are now quoted out of context as though they represent the true spirit of the First Amendment. So think of this a minute. They weren't written until 14 years later after the First Amendment was adopted, his words. And they meant exactly the opposite of what this is intended to mean. And they dug up these words. In 1947, the Supreme Court dug up these words, and out of Jefferson's, they dusted off his letter and found this phrase and used it to actually pervert the real meaning of the Constitution. Let me just pause and ask you a question. If the first sentence of the First Amendment says, Congress shall make no law with regard to the establishment of religion or the free exercise thereof, but if it starts out by saying, Congress shall make no law, then how can the court rule on a law or enforce a law that Congress can't make. First Amendment jurisprudence. The courts tell everybody that they can't pray before a football game, they can't pray before a legislative session, they can't have a Ten Commandments in a whatever. All this Supreme Court First Amendment jurisdiction. And the First Amendment says Congress shall make no law. So if Congress can make no law, how can the court enforce a law that Congress can't make? Think about that. Okay. The real meaning of the Establishment Clause was at the federal level, we're not going to give a preferential treatment to one denomination of Christianity over another. Do you see that? What they're saying is we're not going to favor the Presbyterians over the Methodists or the Methodists over the Baptists, whatever. So it had to do with, that's what they meant by religion. They weren't talking about Mohammedanism, et cetera, et cetera. And we'll see Joseph Story's statement about that, I think, in just a second, okay? Mr. Madison on the floor of Congress said he apprehended the meanings of the words, that's the Establishment Clause, to be that Congress shall not establish a religion and enforce the legal observation of it by law, nor compel men to worship God in any manner contrary to their conscience. Okay, this is what it truly means. And then about 30 years later, Justice Joseph Story, who had been a Supreme Court justice, who wrote commentaries on the Constitution in the 1830s, he said this, probably at the time of the adoption of the Constitution, of the amendment to it now under consideration, talking about the First Amendment, the general, if not the universal sentiment was that Christianity ought to receive encouragement from the state. Did you hear that? The meaning of the founders was that Christianity ought to receive encouragement from the state because, again, the states, because there is a God, our rights come from him, because it's foundational to our form of government. So it ought to get encouragement, right? So far as was not incompatible with the private right of conscience and the freedom of religious worship. In other words, we're going to give general support to Christianity, but we're not going to favor one denomination over another or one set of doctrines. We're not going to get involved in squabbles between Presbyterians and Methodists and Baptists and whatever else. Okay, and we're not going to favor one over the other. We're not going to give grants to one over the other. We're not going to bring in and have an established clergy for the central government that's Presbyterian, for example, as opposed to Baptist, right? All right, so this was what they were trying to do. Again, Joseph Story, I think, says it better than anybody says it. The general, if not the universal sentiment, was that Christianity ought to receive encouragement from the state so far as was not incompatible with the private right of conscience and the freedom of religious worship. An attempt to level all religions, he says, and to make it a matter of state policy to hold all in utter indifference would have created universal disapprobation, if not universal indignation. The real object of the First Amendment was not to countenance, much less to advance Mohammedanism or Judaism or infidelity by prostrating Christianity, like is happening today, right? But to exclude all rivalry among Christian sects and to prevent any national ecclesiastical establishment which would serve to give to a hierarchy, that is to say a church, the exclusive patronage of the national government. You see that? So the real point was not to favor one denomination of Christianity. It wasn't to get rid of Christianity and say Christianity has no place here, because the rest of the documents, Christianity undergirds the rest of the document. All right. So I want to talk for a minute about these tests that the Supreme Court uses to decide cases. Back in 1971, they decided a case called Lemon v. Kurtzman. And so it's called the Lemon Test, which, you can laugh about that because I think the Lemon Test is kind of well named. But they said for a statute has to have a secular purpose. And its primary effect, now they're looking at state legislation right now. What they're contemplating is our state acts like maybe, and let me just, prayer in public schools, a Ten Commandments monument in a courthouse or whatever. They're saying if states do these kind of things, they have a statute that allows them to do that. This is the federal government looking at that statute. Remember, we've got the incorporation doctrine now, where remember the First Amendment was supposed to be a limitation on Congress, and now this is the federal government using the First Amendment as a battering ram against what states can do. Wasn't intended to be that at all, but here we are. And they're saying a state statute must have a secular purpose. What does that mean? If you go back to what Rushdoony said a minute ago about legislating morality, there is no such thing as a truly secular purpose. Every piece of legislation has morality in it. So they're saying the statute must have a secular purpose. And then they say its primary effect must not be to advance or inhibit religion. Its primary effect, advance or inhibit. In a sense, these tests that they invent are these words that are in these tests are subject to great interpretation. They're kind of mushy words, right? To its primary effect. What's a primary effect? It must not be to advance or inhibit religion, right? And then they say it must not constitute excessive entanglement of government with religion. Excessive entanglement. Well, who gets to say what that is? Who gets to say what advance or inhibit? Who gets to say what a secular purpose is? Who gets to say what excessive entanglement is? Well, courts, of course. Judges. In a sense, this jurisprudence is like the Judges Relief Act. It's, you see what I'm saying? It keeps judges in business forever because there'll always be a new way to go. Oh, wait a minute, is that excessive entanglement? I don't know. What's excessive? What do we mean by excessive? So it's all these kind of mush words that instead of just looking at, what does the First Amendment say? Congress shall make no law. What's hard about that to understand? Congress shall make no law. We morph from that into laws that states might make and states, by the way, aren't Congress. Town of Greece, New York, earlier this year, right? Town of Greece, New York. They're praying before their town hall. Well, somebody comes and files a suit against them for a violation of the First Amendment. Well, wait. Is the town of Greece, New York, Congress? No. So that should be the end of the issue, right? First Amendment says Congress shall make no law. What's that got to do with the town of Greece, New York? And by the way, praying before a legislative session is not the establishment of religion. Please write this down. The acknowledgement of God, and put in parentheses, prayer, for example. The acknowledgement of God as the source of law and government is not a violation of the Establishment Clause of the First Amendment. I'll say that again. The acknowledgement of God, for example, by means of prayer before a legislative session, is not as the acknowledgement of God as the author or as the source of law and government is not a violation of the Establishment Clause. Rather, it is an expression of a political philosophy. And that political philosophy just happens to be the American political philosophy. You'll come back to that sentence. Judge Darrell White said that to me. I wrote it down, so I'm asking you to write it down because once I got that sentence in my brain, wrapped my arms around that, I understood this. The acknowledgement of God, yes, the acknowledgement of God, praying in a legislature, as the author or as the source of law and government is not a violation of the Establishment Clause. Rather, it is an expression of a political philosophy. And that political philosophy is the American political philosophy. It's the American view. Okay. I'll repeat that again after class if you need me to, okay? So they say here that the Lemon test, this test that they use, is a framework for analysis, not an ironclad rule. So not only are they have a bunch of wiggle words in the Lemon test, excessive, advance, prohibit, inhibit, whatever, then they say the whole test is just a framework for analysis. It's not an ironclad rule. So the whole thing's a wiggle, right? And Justice Scalia pointed this out one time in a opinion that he wrote. This had to do with a case had to do with school. He said the secret of the Lemon test survival, because he was all in favor of getting rid of the Lemon test. So he said this: the secret of the Lemon test survival. By the way, I think it was about Halloween when he was doing this, writing this, is that it is so easy to kill. It is there to scare us and our audience when we wish it to do so, but we can command it to return to its tomb at will. When we wish to strike down a practice it forbids, we invoke it. When we wish to uphold a practice it forbids, we ignore it entirely. Sometimes we take a middle course, calling its three prongs no more than helpful signposts. Such a docile and useful monster is worth keeping around, at least in a somnolent state. One never knows when one might need him. Okay, so he's making fun, like I would make fun, of this lemon test. He did this in this Lamb's Chapel case, right? And then I guess the majority's foot, I guess they couldn't resist going back at him here. They said, while we are somewhat intrigued by Justice Scalia's evening at the cinema, we return to the reality that there's a proper way to inter an established decision in lemon, however frightening it might be to some, has not been overruled. So, but I think he puts his finger on it here. This test is really just a way to keep them in charge. All right. Or prohibiting the free exercise thereof. Now, for the free exercise clause, we have another test. It's called the Yoder test. It was from Wisconsin v. Yoder back in 1972. And they said that the exercise implies words of action, not just conscience. And in this Yoder test, they said, does the individual, in other words, here is where the government is, in this kind of case, the government is saying, you may not do this thing or you must do this thing. And an individual is saying, wait a minute, that violates my religious freedom of expression, okay, my religious liberty. And so the test that they use to determine cases like that, it goes like this. Does the individual have a sincere religious belief? Well, what's that mean? What's a sincere religious belief? And who gets to say? You've got to walk in there and explain to a judge, to a commissioner, and a judge, through lawyers. You don't even get to talk, they do. And and what's at stake here is your sincerity? Come on. So this is just keeping judges in control. Does government action impose substantial burden upon exercise of that religious belief? Well, what's a substantial burden? In other words, first you have to have a sincere religious belief, and then we're still going to make you do or not make you do something as long as it's not a substantial burden on that religious belief. And then, does the government have a compelling interest that cannot be achieved by a less restrictive means? So the third part of the test is, well, if we don't have another way to get what we want, we get to do it anyway, even if you have a sincere belief, and even if it's burdensome to you. So this is the Yoder test from 1972. So again, instead of these tests, Congress shall make no law. But then you'd have a lot, I guess, of attorneys out of work and judges out of things to do. If I sound kind of bitter about this, I am. Because this is a farce. This is a giant farce, and it's taught in law schools, that this is the law. We're going to get into abridging freedom of speech in just a second. Let me just pause here and we're almost through. But when I do the course other times, this is where I grab my guitar and I sing the song, the Peter, Paul, and Mary song, "I Dig Rock and Roll Music." I'm not going to do that to you today. You're welcome. But here's the point that I would have tried to make by the little entertaining part of using the song. The "I Dig Rock and Roll Music" song, what kind of music did Peter, Paul, and Mary do? They did folk music. They didn't do rock and roll music, but they did a song called "I Dig Rock and Roll Music." What they were really saying by the song was, "I don't dig rock and roll music." They basically talked about how much they loved how much they loved Mamas and the Papas and the Beatles and Donovan, but they were basically mocking them in the song, right? And in the last verse, they say, "But if I really say it, if I really say what I want to say, the radio won't play it unless I lay it between the lines." So they say, but if I really say it, the radio won't play it unless I lay it between the lines. So what they were really, they really wanted to say that they were mocking these rock and roll groups. But they couldn't say it directly because the message wouldn't have been accepted. Here's the connection to the Supreme Court. These tests, the Lemon test, the Yoder test, all these other phony baloney tests, they establish these tests, and like I've suggested to you, this keeps them in business forever because there's always going to be somebody to say what's excessive entanglement, what's a compelling interest, blah, blah, blah. But if they use these tests to actually make law, in their view, they are making law. They are, through this convoluted process, making law, that what they call law. If you are the lawmaker, if you're calling yourself the lawmaker, who are you saying you are? You are saying you're God. What they're doing is playing God. But if they came right out and said to America, well, they've almost done this. But if they came right out and said, we're God, you might go, oh, wait a minute, no, you're not. And you might object, and you might get together and form a Tea Party, and you might go to Institute on the Constitution, or you might get upset, or you might vote some other way, or you might do something, or you might protest, or you might stop paying taxes, or you might do something. You might do something that would be dangerous to them. So they don't come right out and say, we're God. We will make the laws, and we are the law. And tune in tomorrow. See what the law is tomorrow, because we can change it, because we're God. And our authority is unlimited. If they said that, I think they would be worried about rebellion on your part, resistance on your part, so they don't say that. They invent the lemon test. That's my point. Okay, the First Amendment goes on after the free exercise of religion. It goes on to say, we're abridging the freedom of speech. The general principle is that speech is protected, but states which ratified the First Amendment had similar provisions in their state constitutions, yet they still prohibited blasphemy and obscenity, things that were violated God's law, right? And certain forms of expression, we say, are outside the protection of the First Amendment. And the courts, again, have held that speech containing, soliciting crimes of violence or fighting words or obscenity or defamation, you don't have a right to say those things. One of the things John Eisner says about the freedom of speech clause is it's really a two-edged sword. If we're to have freedom of speech, we got to tolerate free speech that we don't like, right? That others that we don't agree with. We got to be tolerant of that. And too often in our kind of liberal world, don't you find when you turn on the Tolerance Boulevard, it's a one-way street? We have to be tolerant of certain things, but my view that that marriage is between a man and a woman is not tolerated. It's not tolerated. I'm violating somebody's civil rights by having that view or expressing that view. All right, freedom of the press, just briefly. The Potter Stewart view, as he expressed in some speeches, was that this clause gives the press a special protection of preferred status as a check on government power. In other words, the freedom of the press, the press is some privileged group that is supposed to be the watchdog on the government. That's a joke. Right. But no, he's serious about that, and that would give the press some kind of special protection. But Warren Berger, in the majority view, said that this clause gives the press no special status or protection. It simply extends the protection of the free speech clause to the print and the broadcast media. Okay, in other words, what you could say, you can also write. Or the freedom of the people peaceably to assemble and to petition the government for redress of grievances. And this arose out of the king's insensitivity to colonist grievances, and that was one factor that led to the Declaration of Independence. The public presentation of grievances can be a safety valve against violence. You know, the people need to be able to gather and express their views. And there are many modern day examples of peaceable assemblies, such as, well, we saw a lot of Tea Parties in the last couple of years, Tea Party movements. Going back to 1963, you could say the March on Washington with Martin Luther King was a piece, was an assembly of people. So this has a long history of a protected province in our culture. Also, there are examples of people petitioning for redress of grievances, such as the We the People group petition by Robert Schultz about concerning the IRS a few years ago, and also my good friend Dr. Mike Hargadon here in Maryland, who presented was part of a group that presented a grievance to the IRS, et cetera. So there is one of the things I think, it's election season. One of the things I think you can ask anybody running for office is, what are the 5 freedoms protected by the First Amendment? See if they know that. See if they know what the 5 freedoms are. A few years ago, right in this very room, I interviewed a gentleman running for governor of Maryland. And I asked him, among other things, I asked him what the purpose of government was and what this oath was about and some things that we talk about, the source of law, where law came from. I also asked him, what's the Third Amendment about? Just to see if he knew. And he had no idea. I said, you don't have to have it memorized. Just tell me what it's about. What's the Eighth Amendment about? What's the 14th Amendment about? You know, what, no hable anglais. You know, I mean, he didn't have any idea. And his handler, his assistant that was with him, said, well, those are ridiculous questions. And I said, well, I don't think so. I really don't think so, because if he doesn't know what my rights are, how's he going to defend them and protect them? He doesn't even know what they are. So knowing what the Bill of Rights, knowing what these rights that have been protected, and also knowing that, remember what I said, that this is not meant to be an exhaustive list. The Ninth Amendment actually says that rights that are not listed here, but that the people already have, they still have. So that's to protect you from that situation I said, if you would stay up all night trying to think of all your rights if you were going to lose ones you didn't list. For homework, that's really the conclusion of Lecture 8 here. For homework, I think we have a couple of video assignments. Oh, read the two Thomas Jefferson letters, please. The letter to from the Danbury Baptist and the letter back to him, so you know in your mind where wall of separation of church and state came from, what it means and what it doesn't mean. A couple of video assignments. The First Amendment, its original text and meaning, which have not changed, by Dr. Herb Titus, which is an excellent review of the First Amendment. Please watch that. Why No Church Should Be a 501c3 Organization by Pastor David Whitney, so that you understand the reason behind the silence of most churches, why they don't stand up against the tyranny of central government, and what can be done to remedy that problem. God bless you, folks. Thank you for your patience, and I hope we got everybody online for Lecture 8. Thank you.
Thank you so much for joining us. And for Lecture 8, we're going to be checking back in with you on Lecture 9. We're going to take a brief break, so please load up your questions right now in the discussion forum on the internet, and all you folks here in the classroom do the same, and we'll open the next lecture here at 8:15. Thank you so much.
Why do the nations rage, the nations rage? Why do the nations rage, the nations rage? Why do the people plot such a vain thing? Why do they plot against the Lord? Don't they know he reigns, he rules? Don't they know he reigns, he rules? And his word is creation, and his will is the law. Why would we do such foolish things? The heart of man has been darkened by the fall. Greed and desire have become his all in all. The Lord will laugh. The sons of men are fools, they'll know his wrath when they strive against his rule, against his rule. Why do the nations rage, the nations rage? Why do the nations rage, the nations rage? Why do the people plot such a vain thing? Why do they plot against the Lord? Don't they know he reigns, he rules? Don't they know he reigns, he rules? And his word is creation, and his will is the law. Why would we do such foolish things? Be wise, you judges, and be wise, you kings. Now fear the Lord, for his is everything, a rod of iron will break those who defy. A blessed crown awaits those who comply, those who comply. Why do the nations rage, the nations rage? Why do the nations rage, the nations rage? Why do the people plot such a vain thing? Why do they plot against the Lord? Don't they know he reigns, he rules? Don't they know he reigns, he rules? And his word is creation, and his will is the law. Why would we do such foolish things? Deny his law and I will perish in the dust. Blessed are those who in him will place their trust. The Lord is kind, and he will hear my voice. His law is love. With trembling I rejoice, I will rejoice. Why do the nations rage, the nations rage? Why do the nations rage, the nations rage? Why do the people plot such a vain thing? Why do they plot against the Lord? Don't they know he reigns, he rules? Don't they know he reigns, he rules? And his word is creation, and his will is the law. Why would we do such foolish things? When our fathers pledged allegiance, it was not to a flag they saw. They declared our independence by bold reference to God's law.
Okay, am I coming up all right? So if you're online, you should have received an email with this document that talks about the question, the excellent question that was raised last time about where's the proof for that phrase natural-born citizen, that phrase only means that both father and mother of the natural-born citizen are citizens. And this gives you the context of that in terms of the Emmerich de Vital's book, The Law of Nations, or Principles of Natural Law, and some of the things our founders said and why that's so important, and the conclusion that not only is the current resident at 1600 Pennsylvania Avenue disqualified by that standard, Bobby Jindal's disqualified, as is Ted Cruz, and who's the other? Marco Rubio. So many that are, being put forward as, these are great presidential contenders. Well, sorry, constitutionally they don't qualify because of that specific reason. So anyway, I wanted to give that to you as an answer to that question. Are we ready to show this little clip? Because it's important to remember what the current political class tells us about our form of government, which Michael mentioned earlier. Questions you might want to ask somebody that's running for office. One of those questions is, what form of government do we have? And you'll probably hear this if we're ready to roll this. Or do I need to punch something?
Yeah, go to the next slide.
Okay.
It's a bigger issue. It's about our democracy. This election is also about our democracy. The court made a terrible decision. It was contrary to the fundamentals of our democracy, because it is essential and fundamental to our democracy. So again, this is a real challenge to our democracy. This is not just an election about our future. It's an election about our future and our democracy. And now it's about saving our democracy.
7 times I counted it. I might have missed one, but what was that, a 2-minute clip or whatever? 7 times she called us or 30 seconds. It's amazing that you can get that many statements that we're a democracy, but it's obvious they want to pound this into our heads because they want us to believe it, even though we have already studied that it's not true. In fact, our Constitution says we're a republic, and the purpose of this federal government is to secure a Republican form of government to all of the states. Well, in this lecture, we're going to look at the rest of the Bill of Rights, 2 through 10 of the amendments. And our intent is to, the student will understand the historical background of the Bill of Rights, specifically the 2nd through 10th Amendments, their original purpose in restricting the authority and power of the central, that is, of the federal government, specifically to understand the historical purpose behind each early amendment, the critical importance of the need to restrict and limit government power, and the extent of the government's intrusion into the lives of the people. Also, we hope that you'll appreciate the framers' intent of the early amendments, that is, the amendments up until the war that I call either the war between the states or the war to prevent Southern independence. But the intent was to limit the federal government's power and authority. And then finally, to develop a framework for understanding the opinions of the Supreme Court in what are considered leading constitutional cases and the tests that the courts have used to decide these cases. Well, Thomas Jefferson, and this, by the way, is inscribed in his beautiful memorial down there in Washington, D.C., he said, "The God who gave us life gave us liberty at the same time. Can the liberties of a nation be thought secure when we have removed the only firm basis, a conviction in the minds of the people that these liberties are the gift of God, that they are not to be violated but with his wrath?" So where do our rights come from? Jefferson clearly saying they come from God, and it's vitally important that we not forget that those rights came from God. Now, one of the things that's almost never printed in most copies of the Constitution that I've looked at is this, the preamble to the Bill of Rights. They just begin with the Bill of Rights, but it's important to see the language of why the Bill of Rights was put there. The conventions, it says, of the number of the states having at the time of their adopting the Constitution, expressed a desire in order to prevent misconstruction or abuse of its powers that further declaratory and restrictive clauses should be added, and as extending the ground of the public confidence in the government will best ensure the beneficent ends of its institution. So they were saying, our purpose is to restrict the federal government to be sure that it stays within the limits that we've created. And as Michael shared, that I came up with this football analogy. You can see the points there about how that football analogy speaks the Constitution's 7 articles of field, sidelines, and end zone are the field of play, and the limits on the power are clearly defined in those 7 articles. But the problem is those boundaries are weak, only some chalk on grass, and many during the ratification debates feared that those 7 articles of the Constitution were too weak as a limit on federal power. And so this Bill of Rights erected a thick brick wall on the sidelines and end zone so no play could go beyond what had been granted by the 7 articles. And ever since then, those who desire to tyrannize over us and steal our rights have punched holes in, created doorways, and achieved their purpose of an unlimited federal government. And so if we were to continue that analogy, today it's not just that they're playing ball out in the stands, somebody's catching the ball way up at the top of the stands. No, they're 5 blocks or even a couple miles from the ball field altogether. They're playing in an area that our founders never would have permitted them to even have a semblance of opportunity to do so. So many of the subsequent amendments do that destruction of the walls built by our amendments. Well, let's talk about the Second Amendment. This one is quite hotly contested today. The right to keep and bear arms. And it says literally, a well-regulated militia being necessary to the security of a free state. Notice what's necessary here. A militia, and we're going to look at what that means. It is not optional. It is necessary to the security of a free state. The opposite of a slave state, okay? The right of the people to keep and bear arms shall not be infringed. This is some of the strongest language we have in our Constitution in that statement there. I think the Second Amendment rightly is understood. From the second of these views, we're going to look at 2 views of how people interpret the Second Amendment. I'm telling you, I believe the second view is the proper, and I will explain why I think the second view is. But the first view that's often promoted today, and many people believe, is the collectivist view, that the Second Amendment only protects the right of the people collectively. That is, all of us together to bear arms. And that means we can only bear arms, so to speak, by the state maintaining a National Guard or the state maintaining a police force, that we individually can't do that. It's just our collective ability when we come together as a group. Now, the individualist view says the Second Amendment protects the individual's right to bear arms, and it mentions the militia only as a reason for this right. So we need to ask the question, because it's important, if the militia and the right to bear arms is necessary, what in the world is a militia? Today, of course, the word itself has been demonized, and that's not by mistake. Anybody that talks about militia is immediately thought of, what? You're a domestic terrorist. You're part of a militia. You're a very dangerous person. You're a person the police want to know about. Department of Homeland Security, we got a militia member here in the room. We better, wait a minute. What is a militia? Let's look at the definition that our founders clearly understood. The meaning of the word militia is not just a National Guard or not just a state police force. Noah Webster's 1828 dictionary, which, by the way, if you want to understand the words as they were understood by our founders, Noah's 1828 Webster's dictionary is the source, because he wrote that dictionary specifically to preserve the meanings of the words as they were at the founding era. That was his purpose in writing. You can read it in his introduction to that dictionary. So he knew that words might be twisted and the meanings of them might be altered over time, so he wanted to give us a fixed standard. This is what they meant in the founding era. So the definition of militia: the militia, he says, of a country are the able-bodied men organized into companies, regiments, and brigades with officers of all grades, and required by law to attend military exercises on certain days only, but at other times left to pursue their usual occupations. So these are not professional soldiers. These are not people who are enrolled as as soldiers, and their whole time is taken up in the business of being a soldier. These are citizens who have normal occupations, and yet on certain days and certain times they are required to participate in their regiment. And the history of this goes way back, even beyond Magna Carta. English law, at least from the reign of Alfred the Great, the records we have there, Alfred the Great required all able-bodied men to purchase weapons at their own expense. They were to purchase weapons and to be available for military duty. So this was a law that if you did not obey this, in other words, if you were called up and you were called to the militia gathering and you didn't show up with your weapon, you were fined. If you had refused to purchase a weapon, you have an even greater fine. So it was not something that was optional at all for the citizens in England. And so the other aspect here is, if the Second Amendment protects only a collective right of the state to maintain a police force, it is completely out of place in the Bill of Rights. Consider each of the Bill of Rights. They deal with your, as we saw in the First Amendment, your right to exercise your Christian faith, your right to freedom of speech, your right to freedom of the press. So if we were to say, if this interpretation, the collectivist interpretation of the Second Amendment, is to be applied to, say, the First Amendment, it would mean you don't have the individual right to publish a newspaper. No, only the collectivists have a right to publish a newspaper. I remind you of the Soviet Union. No individual can print or publish anything individually. It's just the state organs of Pravda or the state newspaper that's controlled by the government. That's the only one. And so if you just transfer that mentality of the collectivist view and you transfer it over to the First Amendment, you see very clearly what it is. It's communist. It's a totalitarian mentality that says you don't have the rights, only the government has powers, and your rights are limited. The framers also saw that the individual ownership of firearms was a protection of freedom against both foreign invasion and domestic tyranny. Because we need to remember what they experienced on the ground here leading up to the War for Independence was tyranny from King George III and from those soldiers who were put on the ground, boots on the ground, who tyrannized the people and actually began to kill some of the people. Boston Massacre being one example, but as things and the tensions grew greater and greater, they saw the tyranny of armed soldiers who were a standing army on the ground during the time leading up to that. The framers saw, therefore, that individual ownership of firearms was a protection, and George Washington, in his first annual address to Congress, this is January 8th, 1790, said a free people ought not only to be armed, but disciplined. to which end a uniform and well-digested plan is requisite, and their safety and interest require that they should promote such manufactories and tend to render them independent on others for essential, particularly for military supplies. He's speaking here about the structure of the militia. And he says, we ought to do everything we can to encourage the militia, and furthermore, we ought to develop industry here that enables our militia to be independent. So that we manufacture our own rifles, and we manufacture gunpowder and bullets, and all. We're independent of having to get those supplies from other countries. Samuel Adams, who's often rightly called the father of the war for independence, said the Constitution shall never be construed to prevent the people of the United States, who are peaceable citizens, from keeping their own arms. What about, O'Malley legislation recently here that says you can't have this and you can't have that gun, and we're gonna fine you, and if you don't register your gun, and on the list goes of tyrannies that we see that are exact opposite of what Samuel Adams said and what he believed. Or Thomas Jefferson, no free men shall ever be debarred the use of arms. No free men. Or Noah Webster himself, I think, explained what's really going on, and this is what you really need to listen for when you hear the propaganda of gun control. This is what Noah Webster said is actually taking place. Before a standing army or a tyrannical government can rule, the people must be disarmed. As they are in almost every kingdom in Europe, the supreme power in America cannot enforce unjust laws by the sword, because the whole body of the people are armed and constitute a force superior to any band of regular or professional troops that can be on any pretense raised in the United States. Awesome statement there. And yet today, that's been reversed, has it not? Because today, we're told you can't have the weapons that the policemen have, and you can't have the weapons that the soldiers have, but we have a standing army in these United States called North Command, in these United States, supposedly there to quell domestic disturbances or what have you, but they're here on the ground, and they are a danger to our liberty and to our freedom. And they do now have weapons, better than the weapons that the average citizen would have, and they do have a power, unlike in Noah Webster's day, superior to ours, which means they could easily drive us into their tyranny and into a kind of slave system. Yes?
One of the things that I use, and it's basically just 3 words that covers a lot of this, and is the history as well.
Mm-hmm.
Registration, confiscation, concentration.
Yes, registration, confiscation, and then concentration. Those are the 3 steps. And Hitler used them, Stalin used it, Mao Zedong used it. Every tyrant does that.
Well, the 68 gun ban was based actually in the 1930s.
Nazi laws. Yeah, right. They were following there's a T-shirt, T-shirt I love that shows Hitler, Stalin, and Mao, and says, gun control works. All the tyrants agree. It works. It gives them power over us. And that our founders knew that. If you have citizens who are godly, honest citizens who are not going to go shoot somebody, they're only going to use weapons defensively to protect God-given rights to property and life, then you have a safe society. But if the citizens are disarmed, then you have a situation where you're entrusting all of your rights to be defended by whoever has those arms. Well, let's think of the policeman for a moment here. The policeman on the street carries a weapon, doesn't he? I have an empty holster here. It's empty because in our government run by crooks in Annapolis, they will arrest me, fine me, and perhaps even imprison me if I put what ought to be in that empty holster, okay? Why in the world can the policeman on the street carry a weapon at all times and I cannot carry a weapon? Well, what's going on here? They say, oh, no, you're not a professional. It's only the professionals that carry these weapons. Well, we need to understand the nature to bear arms by anyone, sheriff, police, or the military, is based on this idea that, is this idea of principal agency. You can only give power to someone that you have in and of yourself. That is, if you don't have the power to do something, you cannot transfer that power or grant that power to someone else. Frank, come up here for a second, if you will, and if you grab the sword on the table over there. Now, if I were going to, say, be traveling in some dangerous places, I'm going to show you this in a minute. It's sharp, yeah. But if I were traveling some dangerous places, like I'm going into Baltimore, and that's a dangerous place, you know. If I were saying, you know, Frank, I want to hire you to be my bodyguard when I go into those dangerous places. Are you going to take the job? Absolutely. Oh, right, great, wonderful. Now, he's armed, and we go into this dangerous place, and he looks around, he sees some people come down the street that way and that way, and he says, I don't like this job. He's not paying me enough to get beat up and maybe killed. And so you say, David, so long. You can go sit down now. So long. I'm not going to help you out here. Now, that's right. No, you haven't been fired. You chose to, abandon the job. Now, the fact that he has abandoned me, does that mean I can't defend myself now? These people are going to come and attack me, and they'll just have to beat me up. I hired him, and he's not going to help me, so I'm helpless. No, of course not. I always have the right to self-defense, even if that person I hired refuses to do his job. Now, where did he get the authority to protect me? Where did he get that from? From me. I granted it to him. And you see, that's what we do with human civil governments. We have decided together as a people, we're going to hire policemen in our community to help protect our God-given rights. It doesn't mean we can't protect those God-given rights anymore. No, we've hired somebody to help us in that job, and we have not in any way surrendered that power. In fact, the only power Frank has to do is the power that I have granted to him as my agent. I'm the principal, he's the agent, okay? There's no way that he can come back and say, David, you have to give up your gun because I have a gun now and you can't have a gun. And yet that's what our government is telling us, saying the police have a gun. Where do they get the right to have a gun? Only from we, the people. If we have no right to a gun, they have no right to a gun. If we cannot carry 24/7, they cannot carry 24/7. It's simple logic, but the propaganda is thick prohibiting this. The reason I bring this particular sword is that Jesus actually referred to this, because when I talk about these things, people get upset and say, David, you're a pastor. You shouldn't be carrying a gun, and you shouldn't be advocating people buy guns. That's terrible. And I say, well, you need to read what Jesus said in Luke 23, because they're in the upper room. I'll get to you in just a second. They're in the upper room before they went out when he was going to be arrested in the Garden of Gethsemane. He said to his disciples, if you don't own a sword, sell your most expensive garment and go buy one. And the sword he was referring to is this. This is a reproduction, not an actual Roman, but it's a Roman gladius that this is a reproduction of. Look at that sword. That's significant weapon, a battle weapon. This is what the Romans used to conquer all of Europe and England and so forth. This was not an insignificant weapon. It wasn't a pocket knife Jesus was telling them to go buy. It was a gladius, because this was the primary weapon for self-defense. It wasn't a huge, long battle sword, but it was a sword that you could carry on your person to defend yourself. And Jesus told all of his disciples, go buy a sword. And if you don't own one, sell your most expensive garment to have one. So Jesus believed in self-defense. In fact, he commanded self-defense of his disciples. And if you're interested in taking that a little bit further, I believe we have them on the shelf back there, a talk I did, God, Guns, and the Constitution, that elaborates further on this. Frank?
A quick irony. There's a local gun range, and as you go about 4 feet inside the front door, there's a big stop sign there. It says stop. All of your firearms must be empty, or something to that.
Mm-hmm.
The biggest offenders are the police. Because if you go in and you're armed,
right,
you get tossed out.
Oh, really?
And can't come back. That's what
their rules are.
Their rules
Yeah.
But they told me, I had a couple of them tell me that, the biggest offenders
Are the police.
law enforcement.
And we need to help train law enforcement people to understand this mentality, that as civil servants, the only power they have to carry a weapon is because it's power that we, the people, have granted to them. And if we don't have a power to carry the weapon, they have no power to carry the weapon. We always say, hey, hand over your weapons right now. Or we, the people, have the power to rescind that. I have the power to fire Frank if I decide, I don't think he's doing a good job, I'm going to fire him. I gave him a weapon. I'm taking that weapon back. It belongs to me. It does not belong to him. It has been a grant, and he does not have power in and of himself. So the Second Amendment, extremely important, very misunderstood in our day. In fact, a lot of politicians talk about hunting and, it's all about duck hunting. So, no. Our founder said it's about preventing tyranny by having the ability to push back against the tyrant who would seek to violate our God-given rights. Michael mentioned this amendment because this is probably the most ignored amendment in our Constitution. The Third Amendment speaks about quartering troops. No soldier shall in time of peace be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. The reason this was so important to our founders is the British had a practice of forcing citizens to house them, to feed them, to allow them to sleep in their beds, to basically take over their home. They said, oh, there's a nice house, and so the general wanted that house, and you're either kicked out of the house, or if you stay in the house, you obviously are subservient to the soldiers. And of course, the law here says the owners can consent to this. An owner can say, yeah, I'll have these soldiers in my house. Or in wartime, but even in wartime, if it's to be enacted, it must be done in a manner prescribed by law. Now, the dangers of troops quartered in homes became very obvious during the War for Independence, tragically obvious. And you could just imagine if you had a group of soldiers who took over your home tonight, who's going to sleep in the nicest bed in the house? Oh, the guys with the most arms, right? Who's going to decide what gets eaten out of that refrigerator or the pantry, or, everything in that house suddenly becomes their choice. They're the power in your home, including the women in the home. I grew up in central New Jersey and an area north of Trenton. I went to high school in the town of Pennington, where this largely took place. The area where atrocities were reported in December 1776, claims of rapes of girls, of pregnant women perpetrated by the British and German soldiers there. George Washington actually wrote March 3rd, 1777 to the governor of New Jersey, and he said this: Robert Combs, a tavern keeper in Pennington, can inform you of a rape committed on the wife and daughter of one John Christopher by the enemy while they lay there. One Philip Farmer's daughter of that neighborhood was ravished by 6 soldiers, and Thomas Keene's daughter was treated in the same manner. Those facts I did not particularly recollect at the time of writing you on the subject of the enemy's brutality. I have since found the memorandums that were taken when our army lay on the other side of the Delaware. And so it's extremely dangerous to give soldiers power over your home. And they experienced that, and that's why the Third Amendment was so important. And today, as Michael mentioned, most people have no idea what the Third Amendment says, yet the Third Amendment is also under attack. There's an article on my blog, and maybe I'll find where it is and make a link to it so that Karen can send it to you in the email. But it basically says this, and this was a decision about a year and a half ago. Obama says your pantry belongs to him. Or more specifically, your pantry belongs to his soldiers. That is, anytime, if he makes this declaration, soldiers can come in and take all of your food. The soldiers can go to a farmer and take all of his food supplies. They can actually take all of his equipment so he can never farm again. They can confiscate everything in his farm because, it's needed for the army. It's the same thing here. The Third Amendment is potentially prepared to be violated by our tyrants in Washington, D.C. today. Well, let's move to the Fourth Amendment, because this one is violated egregiously in so many ways. The prohibition on unreasonable searches and seizures. It says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. And no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. Notice what this does. This says no unreasonable searches and seizures. That is, it's not saying there cannot be any searches, but to be reasonable, the searches have to be accompanied by a warrant. And that warrant has to be under oath. That is, the officer bringing in evidence to usually a judge. Hopefully, ideally, it's going to be a magistrate who's objective and looking at the facts, that they bring this evidence to the judge and say, we believe that a crime has been committed by this individual and we need to investigate, and this warrant will allow us to go into this location and to gather this specific material. Notice it limits it, particularly describing the place to be searched. In other words, you can't say, we're going to search every house in this whole city, like Watertown, Massachusetts, or something like that. Or we're going to search every car coming down this highway. We're going to stop every car and do a search on every car coming down. Wait a minute. That's not a specific, particularly describing the place to be searched and the persons or things to be seized. And so when a warrant's granted, it is limited to certain items that they're searching for and certain places or certain persons. They just can't go into a house and say, well, the warrant said we were looking for cocaine. Oh, but this guy's got weapons over here. We're going to grab the weapons. No. The search says, no, only those things listed. Oh, but the police always violate this one. They always grab all the weapons in a person's home, say, yeah, we were searching for cocaine, but we found the weapons. We have to take all the weapons too. Why? They're directly in violation of the Fourth Amendment. And our founders understood that if we allow the police this kind of power, it basically invades our personal privacy, and we have no protection. The key word unreasonable doesn't say all searches and seizures, only those that are unreasonable, and normally that must be accompanied, therefore, by a warrant. By the way, the warrant is only issued under oath. That is, the officer bringing the evidence must swear that he's not framing the individual, that this evidence has been rightly obtained, etc., so that if the officer is seeking to frame or set things up, he's actually damning himself by taking an oath and to bring this evidence of probable cause that's set forth in the affidavit that he brings, that is the source that the warrant is written from. And ideally, a neutral and detached magistrate is making this decision. Now, when we look at this, there are exceptions that the courts have ruled, and we might debate some of these exceptions, say, okay, maybe some of these are reasonable, some may not be. They said in exigent, that is urgent circumstances, the requirement of warrant doesn't apply. So some of those might be search incident to a lawful arrest. They've actually arrested the person. Now say, we're going to search your person, we're going to search your surroundings. In hot pursuit of a felon, that is if someone they're chasing goes into a home and they pursue them into that home rather than getting a warrant to enter the home. And when there's a bona fide emergency, and again, the courts have said lesser invasions of privacy like stop and frisk can be justified with less than probable cause. That's a very dangerous thing. Someone sent me a link to a video that an individual put up this past week where he had a dash cam, or maybe he just had his iPhone on his dashboard, but this was a DUI checkpoint. Every single car on this street was being pulled over by the police, and they were demanding, essentially, to be able to do a breathalyzer test or so forth to prove that you're not drunk. Wait a minute, that's assuming that you're guilty and you've got to prove you're innocent. No. That's the opposite of our legal system. You're innocent until proven guilty, and a mass pulling over of every driver on the street is a violation of the Fourth Amendment. They cannot do that. And yet they did, and he had a little discussion that got rather heated because the police officer was about to do him violence, it appeared. He ripped his door open and demanded this and that, and it was a rather ugly altercation, and the police officer was wrong in everything that he was saying. But he was demanding of this man that he submit to this violation of the Fourth Amendment. And the fellow reminded him, the Fourth Amendment says, doesn't matter, you're going to do what I tell you to do or you're going to get hurt, is the implication of that. And so we have a situation today where many people in our society, because of the supposed threat of terrorism, have been willing to surrender this Fourth Amendment. And the courts, in the past time, the courts have realized that police are prone to violate the Fourth Amendment, and so they've created what they call the exclusionary rule, that evidence seized in violation of the Fourth Amendment cannot be used in court unless it was a good faith error. Who decides what's a good faith error? Okay, questionable. And this is not part of the Fourth Amendment, but something that courts have adopted because they thought it was necessary to make sure the police abide by the Fourth Amendment. So the Fourth Amendment limits government's authority to invade your privacy and your property and your records. And yet our government today does that in egregious ways. We'll talk about that in a moment. But let's step back and see where the roots of this idea that you have Fourth Amendment rights comes from. Because many would say, well, why shouldn't the government be able to investigate you? Why shouldn't the government know what you're doing with your finances? And so why not? Well, it's based upon Exodus 22. And Matthew Henry, in his commentary on this passage, says, a man's house is his castle. This is the source of what's often called the castle doctrine. And God's law, as well as man's, sets a guard upon it, upon your home. He that assaults it does so at his peril. Interesting wording. And the law of England, this is William Blackstone, basically commenting further on what Exodus 22 has said and so on. But he said the law of England has so particular and tender a regard to the immunity of a man's house that it styles it his castle and will never suffer it to be violated with impunity. For this reason, no doors can in general be broken open to execute any civil process, though in criminal cases the public safety supersedes the private. Hence, also in part arises the animadversion, that is the resistance of the law upon eavesdroppers and nuisancers and incendiaries, and to this principle, it must be assigned that a man may assemble people together lawfully without the danger of raising a riot or unlawful assembly in order to protect and defend his house, which he is not permitted to do in any other case. So, English common law, American law, says that you have rights that the government cannot investigate you unless they have probable cause that you have committed a crime. You are protected from the government just prying into your affairs and into your life to try to find a evidence that you've committed some crime. Well, you know as well as I that egregious violations of this are taking place today. Not only the DUI stops that are happening around our country, the Patriot Act that's mentioned there at the bottom of page, 198. The bottom of that page talks about that. We know that the NSA listens to all of our phone conversations, and they assure us, I listened to a statement by the former Michael Hayden, the former NSA and CIA director, and this was a statement he made May 12th of this year. And the director was being questioned about this gathering of data from people's phone conversations. He said, well, don't worry about it. It's only the metadata. And one of the panelists said, but the metadata is very dangerous because they can know a whole lot about you just by who you've called, how long you talked to them, where you were calling from, all those details. Even if they don't know the content of your phone conversation, it's extremely dangerous. And Hayden affirmed that. He said, yes, we have killed people just based upon that metadata. We have killed people. He admitted the CIA has killed people based on metadata that they gathered by phone calls. So it is extremely dangerous to have the government snooping and spying into every area of our life. Since the Patriot Act, all of your financial transactions, with the exception of cash, are tracked. You use a credit card, they know where you bought it, they know what you bought, how much money you spent, they know every detail about your bank account and your transactions, all of it. Illegally, a violation of the Fourth Amendment. Where did they get a warrant to spy on every single American's financial transactions? There's nowhere that they're granted that power, and yet they have said, be very, 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 very scared of that towel head over there in the cave. He's your danger. No. That's no danger to you. The federal government, NSA, right down the street here, is a greater danger to your God-given rights and liberties than anybody wearing a towel on their head over in some cave in Afghanistan. Our government has destroyed the Fourth Amendment. And they've done it with most Americans' complicit agreements. We need to be terrified of the terrorists, and therefore we need to surrender our Fourth Amendment rights. We should not. We should fight back, and we should see that our state governments, which are obligated to follow the Fourth Amendment as well, our state governments refuse to allow those who are violating the Fourth Amendment at the federal level get away with it. I was initially encouraged by some of the legislators last legislative session in Annapolis. They said because the NSA is violating the Fourth Amendment, we as a state need to do something about that. We're going to cut off their water. We're going to cut off their electricity. We're going to cut off their sewer. We're going to put them out of business by cutting off their essential sources that come from the state of Maryland. Well, that bill didn't last very long. It was dead within moments because I'm sure that they had ways and means of blackmailing them. After all, if they're listening to all your phone conversations, they know all your details of everything. They know more about you than you know about yourself. They can find some dirt on you that they say, well, we're going to expose this on you, senator or delegate in Annapolis. You want this to be known by everybody? Yeah, that bill died very quickly. But we need to find people with some guts who will stand up to the tyranny that's taken place in violating our Fourth Amendment structure. So the Fourth Amendment says the government can't go on a fishing expedition and investigate you unless there's probable cause you've committed a crime. The Fifth Amendment now steps into the next level. Basically, if you look at the Fourth Amendment through the Eighth Amendment, it deals with the criminal process and the judicial process. If they suspect that you've done something and then they get a warrant and then they investigate and they find there really is evidence, then you're going to move towards a trial. The Fifth Amendment's designed to protect you in that scenario, to protect your personal and property rights. No person, it says, shall be held to answer for a capital or otherwise infamous crime. A capital crime is one where you could be executed, okay? You could lose your life as a punishment for a capital crime. Unless In other words, you can't be tried for capital crime unless on presentment or indictment of a grand jury has to look at the evidence that the government is claiming is against you before you can stand trial regarding a capital crime or other infamous crime. And this is accepted, of course, in cases involving land or naval forces. In other words, if you're in the military, there's a separate justice system, a military justice system, and that's not the same here. So if you're in the military, you don't have that protection that's assured here while you're in service, or service in the militia when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. So let's walk through this. There has to be a grand jury indictment for any capital or infamous crime, and many people make a mistake thinking the grand jury, when they indict somebody, declare that they're guilty. No. Grand jury is simply deciding, should this case go to trial? We're going to look at the evidence that the government has gathered, but the grand jury, if they do their proper job, does their own investigation because they recognize we may be given a skewed picture. There's only one side of the story being presented here by the prosecutor. We need to investigate the rest of this. They make a decision, should this go to trial and should this person be tried, but they do not decide guilt. Just indictment says it's going to go to trial. And this means that the grand jury serves as a buffer between us and the state because nobody should be dragged through the court system, the expense and the trauma and the jeopardy of a trial, unless a grand jury of fellow citizens, a grand jury of peers, have determined that there is probable cause that should lead to a trial. As a fact-finding body, they also act as a check on the government itself. When a grand jury is formed, they have power to investigate anything. They could go down to the county and say, open your books. We're not so confident that you guys are being honest with your bookkeeping. Show us that. I had a friend who served in Carroll County on the grand jury, and one of their things was to investigate the prisons. So one day they went and they traveled to each of the prisons in the county to investigate and see what's taking place in the prisons because they are a check upon our government. Many people don't understand this, and they think, if I serve on a grand jury, I just got to do what the prosecutor tells me to do. Prosecutor's going to bring in evidence and so forth and explain things, but he's not your boss. You're independent of him and ought to serve as a check upon government power. As we mentioned, military cases are accepted in the grand or in all of this criminal process.
Grand jury can only ask for that information if they have a pending case. Is that correct?
No. The grand jury can investigate.
Willy-nilly say, show me your book.
Yep. They can go. In other words, if they're a state grand jury, they can obviously investigate state issues. If they're a county grand jury, they can investigate county issues. They can't, basically jump government levels to investigate. But the level of government that the grand jury is formed on has the power to investigate anything they choose at that level of government. It's the
grand jury is impaneled for a specific time.
Yes, because during that time period, they have the power to do that. Yes.
Does a judge preside over these hearings?
No. Often what happens, and this is the testimony of my friend who went through Carroll County, he said, the prosecutor basically comes in and pretends he's the boss. And he's going to tell all the grand jurors what to do. And he said most of the grand jurors just comply because they've never served on a grand jury, and he's the government employee, he must know what he's talking about, which is why we have a course on the jury, because it's important when you serve on a grand jury or a petit jury to know what your job is, because you won't be told by the government employees what that job really is. In fact, they don't want you to do the job our founders designed you to do, because to do that means you have too much power, and they don't want you to have that power. And so my friend tried to resist the prosecutor, and the prosecutor kept just shoving him aside and not allowing. He ultimately didn't prevail in terms of persuading the other grand jurors to say, we really don't have to abide by what he's saying. Yes, we need to take his evidence. Yes, we need to look at the cases he's bringing before us, but his power is limited, and the grand jury is above him. So anyway, encourage you, if you after this course is complete, you might want to look at the jury course as well. Now, notice the Fifth Amendment expressly recognizes capital punishment. You could lose your life, and it's talking about that, and we'll relate that in a moment to the Eighth Amendment and understanding the Eighth Amendment properly. Notice the protection here against double jeopardy. That is, you cannot be tried twice for the same crime in the same jurisdiction, or same offense in the same jurisdiction. They might try at a different level of jurisdiction. That's a trick often played, you know. It failed at the state level, so we're going to take it up to the federal level, and we're going to try it at the federal level because we didn't succeed there. But you can't be tried in the same jurisdiction for the same offense. That is double jeopardy. And this is designed to prevent government harassment because the king had a favorite way to ruin you as a subject. He just kept dragging you to court and dragging you to court and dragging you to court. By the time you're done, you're absolutely broke. I don't know if anybody has read or seen Bleak House, a terrible tale by Dickens about how an individual who had a vast fortune was ruined by lawyers dragging the thing through court, and he never got the money. By the time he was about to get the money, it had all been eaten up by the lawyers who dragged it through court one time after another. And that kind of government harassment is what our founders wanted to prevent from taking place. And they saw it all too readily. Also notice here what's often spoken of when we talk about the Fifth Amendment. When somebody says, I plead the Fifth, they're saying, I don't have to say anything. That is, you have a right not to implicate yourself by giving testimony. There's no compulsory self-incrimination. And the reason for this is, consider if the government can coerce you to say something. Ultimately means they can force you to confess something, and that confession might well be false. You know, you might just say, please, just take the thumb screws off. I'll say whatever you want me to say. I'll sign whatever you want me. Just stop torturing me. Please, sew me up rather than cut me open. Please take me off the rack. End the torture, and I'll put whatever you want on paper. And so false confessions are obviously part of that process, because coerced confessions violate basic human dignity, being forcing a person to cooperate in their own self-destruction. And it's interesting that courts have recently kind of ruled that custodial interrogation, that is, whenever the police have you and are questioning you, custodial interrogation is inherently coercive. Therefore, the police must read the Miranda rights to the suspect to ensure any waiver of his Fifth Amendment rights is truly voluntary and intelligent. And as I was telling you about that young man who was pulled over for the DUI stop that everybody on the road was being pulled over, he said several times to the police officer, am I free to go? And the police officer didn't say, no, you're not free to go, which would be a statement, you are under arrest. If you're not free to leave, then you're under arrest. But he basically said, you can't leave. Well, he repeated the question, am I free to go? And rather than saying no, the police officer said, no, you're being detained. He wouldn't say no. He said, you are being detained in order for your own safety. We're detaining you. Your own safety, you're detained. Anyway, went around several different times, and finally the young man said, the police was asking him questions like, this address on your driver's license, is this where you currently reside? And he said, I plead the Fifth. I will not say anything further unless I have an attorney in the presence. In other words, he was claiming that this is an interrogation that you police are engaging me in here, and I have a Fifth Amendment right not to say anything to you at all, and I have a Fifth Amendment right to call a lawyer and to only communicate to you through that lawyer should I choose to do so. So I think this is a important protection. And if you think about it, the amazing thing is that our Lord and Savior knew about the Fifth Amendment before the Fifth Amendment was written. Do you remember when he was tried? He went before the Sanhedrin, and they said, you're not going to say anything to us? He remained absolutely silent. He said not a word. Then later he was dragged before Pilate. Another kangaroo court was being conducted, and Pilate said to him, you're not going to say anything to me? Don't you know I have the power of life and death over you? And Jesus chose to say something to him. He said, no, you have no power except that which is given you from above, reminding Pilate that he was going to answer to God on Judgment Day for whatever he did there in that kangaroo court. But Jesus knew he didn't have to say a word. Why? He understood this principle that's part of our Fifth Amendment, that you have a right to remain silent. Furthermore, you cannot be deprived of life, liberty, or property without due process of law. Without due process of law. That means there must be a just trial and a process that takes place where you're charged. And we're going to see the elements of that in the Sixth and Seventh Amendment. But how does that fit with the National Defense Authorization Act, which says that if the government deems you to be a threat to the security of the government, whatever that's defined as, they can simply grab you up, they can actually take you to another country, they can torture you, and they can never let you go. Never having charged you with having committed any crime whatsoever, never putting you on trial before any type of body, or if they put you on trial, it's before a military tribunal, but you're not in the military, so that's illegal. I mean, the violation of our Bill of Rights are so egregious in our day, but you know what? Most Americans don't know it. And they say, well, oh, they got to protect us from that towel head in the cave over there. We're very, very scared. Well, no. We have graver danger from those who are violating our Fourth Amendment, our Fifth Amendment. Far graver danger than from somebody in some foreign country who claims to be a threat to us. I would argue the real terrorists are in Washington, D.C. Those are the ones we need to be concerned about. But the way to fight them is to know these elements of our Constitution and to teach other people so that we can bring a groundswell of support back to return and a restoration of constitutional law. The other element here in the Fifth Amendment is, fifthly, they cannot take private property for public use without just compensation. This is the eminent domain clause that the government sees your property and says, well, we need to put a highway right through the middle of your property. If they're going to do that, and they might say, really, it's for public good and everybody's going to benefit from this highway, and so your private property has to be taken. We're going to give you just compensation for your private property. That must be the case. However, there's several questions here. What is a taking? Is it a taking just when they come and literally remove you from your property? My neighbor, who's gone through this experience with the building of Route 100 right through this area here, he had a piece of property, and they basically said, this is what we're going to pay you for your property. And he tried to, object because the neighbor, who was more politically connected than he was, with the same piece of property in the same area, was getting a lot more money for his property. He said, wait a minute, this not, he didn't win. They just gave him. 50 years later, he still remembers the injustice of that taking. But what if the government doesn't actually take title to your property, which is what eminent domain encompasses? What if they don't take the property altogether, but they limit your use? They prohibit you from building a certain type of building on your property. They prohibit you from doing certain activities, like you can't conduct the business out of your property, or you can only conduct certain types of business out of your property. Is that a taking? I think that's an important question. Or how about the other elements that have entered now that the Supreme Court has ruled in Kelo v. New London, that essentially any government can take your property and pay you anything they want. In other words, just compensation is no longer part of the picture, and not only take your property, but then not even use it for public purposes. In the case of New London, what they were doing is all this waterfront property that had, lower class housing in it, so it wasn't a great tax revenue for the city of New London, Connecticut. They were going to sell the whole thing, which they ultimately did, raise all the houses and sell it to a corporation. I think it was a drug corporation. It was going to build this magnificent facility there, and lots of tax money would come to the city of New London as a result. So they'd make more money in tax revenue than they would from all the people that live there on that property. Yeah, and so they went and they did this, and ultimately Kelo fought it all the way up to the Supreme Court, said this is not a Fifth Amendment taking because you don't have a public purpose. The only purpose you have is more money into the pockets of the greedy politicians, which reminds me of a proverb that says there's two things in life that are never satisfied, an empty womb and a leech. Both of them call for more, 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 and that's what we have in government today. Greedy government is one of the biggest problems we have. They're never satisfied with enough. They want more, more, more until the blood-producing creature is actually drained of any life they have left and they're dead, which is really what's happening here in Maryland as people are leaving in droves because they're being taxed to death. So even if they don't take your property, they are not to... in other words, what I see, the proper understanding is they are not to regulate your use of the property so that you effectively can't do anything with it that you choose to. If it's your property, you should be able to do what you choose on that property, providing you're not harming anyone else. That is, if you're doing something that's harming your neighbor by some industry that's not permitted. But if you're doing something on your property, as long as it's not damaging your neighbor directly, I think it ought to be permitted. Sixth Amendment. Now, if you've gone to trial and you're in the midst of that trial, we're going to talk in the Sixth Amendment about your rights as a criminal in a criminal case, defending yourself in a criminal case. In the seventh, we'll talk about civil cases. But in the criminal cases, it's this. In all criminal prosecutions, the accused shall enjoy the right to a speedy trial, a public trial, by an impartial jury of the state and the district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and causes of the accusation, to be confronted with witnesses against him, to have compulsory process for obtaining witnesses, that's subpoena, in his favor, and to have the assistance of counsel for his defense. Very clear statement of your rights in a criminal trial. Speedy trial, well, that depends on how you define speedy, but oftentimes trials take years before a person actually comes to trial. And the backlog of cases often means that speedy doesn't seem speedy at all in anybody's definition. Public trial, very important that trials be public, because if people are there and reporters are there, it holds the judicial system accountable. That is, if it becomes a kangaroo court, the reporters can write about it. They can report to other people. So it's very important that it be public, which, by the way, the military tribunals envisioned by NDAA are all private. There's no outside witnesses to those tribunals if you're tried before the military tribunal, and there's no right of appeal. Once the judge in a military tribunal says guilty, you cannot appeal it. You're finished, which is completely in violation of our Constitution, our Bill of Rights. The jury and state of the district, it needs to be people who live in the area that you were accused of having committed this crime in. You are to be informed of the charges ahead of time so that you have time to prepare a defense in your case and be able to confront and cross-examine accusers. So if somebody accuses you of having committed a crime, you should be able to meet that person eyeball to eyeball in the court, and probably through your attorney, question their testimony to see if they're being truthful. How many of you have gotten one of those tickets in the mail? And you go to court, you can't cross-examine those because it's a machine. It's not an individual. Those are completely illegal, and I know that there's a bill here in Anne Arundel County, and hope to testify on it next Monday, to get rid of all the red light cameras in, at least in Anne Arundel County, because they are illegal. They're a violation of this principle right here. Sixthly, a subpoena power, the power that you could force other people to come to court and testify on your behalf for your defense, and assistance of counsel. That is, if you can't afford counsel, then one will be provided for you by the state. So those are in criminal cases. Let's move to civil cases, which is what the Seventh Amendment deals with. In suits at common law, where the value in controversy shall exceed $20, and by the way, that has not been changed since 1791. It was $20 in 1791. It's still $20 at the federal level. The right of a trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of common law. Notice several things here. We mentioned the monetary amount, but the bigger picture is, in most civil cases that are not at the federal level, you don't get a jury trial at all. Here in Maryland, I think it's now $15,000. Unless your case reaches a $15,000 controversy, you're not going to have a jury trial. And when you have a jury trial, it's only 6 rather than 12. And that's changing things enormously, as they've done here in the state of Maryland. And in addition, we need to see that it's the jury that our founders were saying is your best possibility of seeing justice done in your case. A jury of your peers. And so I would encourage you, if you ever receive a summons to jury duty, look forward to it as an opportunity to help your neighbor see justice to be done in their case. A judge himself cannot substitute his opinion for that of a jury unless, and again, this is one of those court rulings, unless the judge determines the case was erroneously submitted to a jury or that no reasonable jurors could have reached that verdict. But that's kind of submitting the judge's opinion for the jury's opinion. So I don't even know that that's really true to what the Seventh Amendment is saying. Now, if you've been tried and you've been convicted of some crime, then the Eighth Amendment applies to your situation. Criminal punishments. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. These are all important protections in the sentencing phase. That, first of all, even before sentencing, no excessive bail is prohibited. So the reason that bail is permitted at all is that you're assumed to be innocent until proven guilty. Well, once you're charged and arrested, why leave you in prison until the trial? If you're innocent until proven guilty, you should be free on bond. That is, there's a guarantee that you're going to appear, and if there's no danger to public safety, that is not if you're convicted as a mass murderer and you've murdered 100 people, might just say, well, we don't think it's possible to let you out. You appear to be too dangerous, or unless you're likely to flee, and that's the purpose of the bail. The money put up for bail is to make sure the defendant does not flee pending the trial, that he comes and appears because that money he's put up he's going to have to pay unless he appears at the trial. And it should be no more than necessary to ensure the defendant's appearance, and that depends, of course, on circumstances, both the nature of the offense as well as the defendant's record and his ties to the community. Does his family live in the community? Is he been here a long time? He's not likely to leave the community before the trial takes place. Now, no excessive fines as well. What is excessive? That which is unreasonable considering the nature of the offense. All the way back in 1215, the Magna Carta defined excessive as fines and forfeitures that deprive a defendant of his living. So suppose, for example, you were an auto mechanic, and they made the fine that they were going to confiscate all of your tools, and they were going to confiscate all of your equipment. So everything that you own is gone. Well, you're not going to be able to be an auto mechanic. It's going to take you a long time to earn enough money just to be able to purchase back all the tools and equipment you needed to earn a living in your particular profession. So that would be excessive, and Magna Carta established that way back in 1215. No cruel and unusual punishments. What's that mean? Usually, the framers meant unusual and unreasonable by torture. The English, you study English history, boy, it's a really gruesome. They're not too far off at times like the Taliban in terms of how they execute people. And, if you were to go into medieval England and you walk into any major city, you would see rotting corpses hanging in cages. And, people's heads that had been stuck on spikes around the city walls. And, these kind of gruesome scenes were very typical of that day. And what they often did is torture somebody in the process of executing them, while they're still alive, disemboweling, taking their intestines out while they're still alive and mutilating them while they're, just really gruesome, torturous ways of killing someone. And our founder said, no, we're not going to do that. Yes, people may be executed, but if they're going to be executed, it is not torturing them to death and mutilating them in the process of executing them. Now, the framers never considered capital punishment cruel and unusual. We just saw that when we looked at the Fifth Amendment. They saw that you might lose your life for a capital crime if you're guilty of that capital crime. It was not cruel. It was not unusual to put someone to death. However, in 1972, Justices Brennan and Marshall of the Supreme Court argued that, the Eighth Amendment must be interpreted according to an evolving standard of decency, and that society has evolved to the point that capital punishment is now cruel and unusual today. In other words, they admitted they were changing the standard from the standard of our founders, and they claimed that this was the evolving standard. But that's rather dangerous, to give to the Supreme Court or any body the power to change and evolve the standard, because it disregards absolute truth. And society is more prone in the history of the world to devolve and go downward, to become more barbaric and not evolve upward. It's unusual for any society to go upward. So this is not a safe thing for us. So those amendments, 4 through 8, deal with the entire process from when you're suspected of having committed a crime, to when you're approaching trial and what needs to happen prior to trial, to when you are at trial, and to then the Eighth Amendment dealing with punishment if you are convicted of guilt. The Ninth Amendment deals with, as Michael said in the previous lecture, could you write down tonight all of your rights, and would you make a complete list? It says the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. And this was in answer to Alexander Hamilton's objection that we saw in the last lecture, that it could be dangerous to put out a Bill of Rights because all your rights might not be listed, and a future government might assume that if it isn't listed, then it is lost by you. So Madison offered this Ninth Amendment to answer that objection. But it's important to think about their rights. Your rights are from your Creator. He is the one who defines what those rights are. You have rights that are not mentioned in the Bill of Rights of the Constitution. And I appreciate our Maryland Constitution, because our Bill of Rights here in the U.S. Constitution is only 10. In Maryland, the Bill of Rights is 47. It's called the Declaration of Rights, 47 specific articles. And the one that isn't mentioned at all in our U.S. Constitution, but is a God-given right that's actually referred to in the Declaration of Independence, is what I call the right to revolt. That is the right to overthrow the existing government because that government is failing to secure your God-given rights. And it's Article 1, that all government of right originates from the people, is founded in compact only, and instituted solely for the good of the whole, and they have at all times the inalienable right to alter, reform, or abolish their form of government in such manner as they may deem expedient. We have the right to get rid of Annapolis and replace it with a government that will protect our God-given rights. And it's the very first article of our Bill of Rights, the Declaration of Rights, in our Maryland State Constitution. I had some fun once when I was testifying in Annapolis because one of the delegates who knew the Maryland Constitution, which is an unusual thing, asked me in my testimony, I'd given testimony regarding some particular bill, and he asked me to read that to the rest of the delegates there because he knew the rest of the delegates had probably never heard that before. That we have a right to get rid of Annapolis and put a government in place that will protect our rights and not steal us blind as the current one seems to be doing. So this Ninth Amendment is very important to protect our rights. And the key word there is retained. The Ninth Amendment doesn't give any new rights to us. Rather, it protects those rights which are already recognized as from God, recognized in English common law as well as American common law. So the right for a woman supposedly to hire a contract killer to murder her unborn baby, that's a right that was supposedly invented. It didn't exist in any of our founding documents, didn't exist in English common law or American common law. It was invented in 1973 by the Supreme Court. They do not have the power to invent new rights. They can only talk about retaining our God-given rights because our rights come from God to us as people, and we, the people, give delegated enumerated powers to the civil government that we, the people, create to protect our God-given rights. Now, moving on very quickly here to the 10th Amendment, the powers not delegated to the United States by the Constitution, nor prohibited by it, that is, by the Constitution to the states. And we know that there's a whole section in Article 1, Section 10, that restricts state powers, says states cannot do this, states cannot do this. So if it's outside that series of restrictions, these rights, or these powers, excuse me, are reserved to the states respectively or to the people. So the only powers we have given to the federal government are the ones listed here in the Constitution. They have no powers outside of what we have given them. In fact, any powers outside of what's listed here in the Constitution, as it says here in the 10th Amendment, belong either to the states or they belong to us as individuals in society. This is the cornerstone of freedom, and it sets in concrete our founders' view of a covenantal nature of government by which the government only has such power as we, the people, delegate to it through the Constitution. And by the way, it doesn't get to determine what the Constitution means. It alone can't say what its powers are. That's the job that we, the people, need to hold them to prevent them from overreaching in their powers. This 10th Amendment is largely ignored today, but there is an encouraging move taking place as many states are putting forward 10th Amendment type of resolutions, basically making a statement to the federal government. We recognize that your powers are limited by the Constitution, and we also recognize that we have a duty as a state government. If you overstep your constitutional powers, we don't have to obey what you're doing. Now, many of those resolutions are just resolutions. They don't have any teeth in them, but there are some states that are beginning to put forth resolutions that are beyond that, that actually have teeth in them. For example, Wyoming has a law regarding the Second Amendment because the federal government claims that it can regulate all guns in the United States. All guns, and they say, oh, we do that through the Interstate Commerce Clause, you know. And Wyoming has passed a law that says if a gun is manufactured in the state of Wyoming and it's sold in the state of Wyoming, federal regulations have no power over that at all. And in fact, they've added some teeth to it that if any federal bureaucrat comes into the state of Wyoming to do anything about any guns that fall under that law, manufactured, sold in the state of Wyoming, that federal official is going to be fined and may face prison time for violating the Constitution. I applaud the state of Wyoming for doing what all the states should begin to do, put the federal government back in the constitutional box and keep it there. When we look at our Bill of Rights here, we've just done a really brief blast through them. We have to ask, what has happened? I mean, the rights are so clear, and on paper they're so easy to understand. What in the world happened to destroy, at this day, I would argue that all 10 of our Bill of Rights, if not under direct and severe attack, some of them are completely obliterated. The Fourth Amendment basically is non-functioning at this point. And you know, you go through each of the amendments, many of them are non-functional. What happened? Well, I would argue it began with this fella, FDR. he came up with in his address, his annual address to Congress, January 1944, a New Deal and a new Bill of Rights. And he actually admitted in his speech, the one supreme objective for the future can be summed up in one word: security. This republic had its beginning and grew to its present strength under the protection of certain inalienable rights, among them the right of free speech, free press, free worship, trial by jury, freedom from unreasonable searches and seizures. I like this. He's walking through the Bill of Rights. This is good, at least where he started. They were our rights to life and liberty. Now, this is where he goes off track. As our nation has grown in size and stature, however, as our industrial economy expanded, these political rights proved inadequate. Pause right there. What? What? They're not inadequate. Doesn't matter that we're an industrial nation and we were an agrarian nation before. They're still our God-given rights, and these protect our God-given rights. He goes on. They proved inadequate to assure us equality. Now, here's where it's really about. Our Bill of Rights do not assure equality. You're not all going to drive the same car. You're not all going to live in the same house. You're not all going to have the same level of income or education. No, equality is not what the Bill of Rights are about. It's about protecting our God-given rights for each of us. Each of us is going to have a different path in some degree, and so equality is not what the Bill of Rights is about. But he goes on to say, they've been inadequate to assure us equality in the pursuit of happiness. Again, trying to pull in a false interpretation of the Declaration of Independence. A second Bill of Rights, under which a new basis of security and prosperity can be established for all, is what he proposed there in 1944. Notice this list, and I ask you to see how many of these elements in this list have been fulfilled in our day. We have accepted the right to a useful and remunerative job. Oh, it didn't come up yet? You've got a guaranteed job that's useful, that you think is useful, and you get enough pay? Is that something the federal government's guaranteeing you? You have a right to earn enough to provide adequate food and clothing and recreation. Hey, you get a promised vacation. Is it a cruise or, you get to, wow. Boy, a right to every family to a decent home. Who defines decent? But, oh, yeah, here's the federal housing program. Remember all those houses or those apartment buildings they build all over the country, Section 8 housing, and that's where it comes from, FDR. A right to adequate medical care. Here's where Obamacare originated. It originated with FDR. His dream that adequate medical care for every American. The right to adequate protection from the economic fears of old age, sickness, accident, and unemployment. There it is. Unemployment insurance, health insurance, Social Security, old age, the fear of, when you're not able to work anymore, that you're going to be cared for. There's the promise. Government will take care of you. The right to a good education. There's free public education. All these spell security. FDR proposed an un-Bill of Rights. I would say the opposite of a Bill of Rights. Instead, proposed a gargantuan government that would steal from us and impoverish us in order to accomplish its socialist goals, not the goals of our founders at all. And I like what Franklin said regarding this. Those who would give up essential liberty to purchase a little temporary safety, using the same word FDR did, safety deserve neither liberty nor safety. I agree with Benjamin Franklin, and I disagree with FDR regarding what is most important. Well, let's quickly review the Bill of Rights. If you say this out loud, this can help you remember what each one is. So if somebody says third, you remember what it's about. The first, freedom of religion. Say that. First Amendment, freedom of religion.
First Amendment.
Second Amendment, keep and bear arms. Second Amendment, keep and bear arms. Third, my home, my castle. Third, my home, my castle. Fourth, no warrant, no search. Fourth, no warrant, no search. Fifth, personal and property rights. Fifth, personal and property rights. Sixth, criminal defendants. Sixth, criminal defendants. Seventh, in civil cases. Seventh, in civil cases. Eighth, when punished. Eighth, when punished. Ninth, unenumerated rights. Ninth, unenumerated rights. And 10th, undelegated powers. 10th, undelegated powers. Thank you so much. Questions, comments, or thoughts you have?
Now's your chance to sell a video.
Oh, yes, there's a video there. What is it? Michael's video on interposition. That's your homework, and as well as completing the review questions. And that, by the way, that interposition is very important because it describes what the local and state government should be doing when they see federal tyranny, see the kind of violations that we've been talking about tonight. Yes?
Question about the fourth.
Yes. Amendment. The Fourth Amendment. No warrant, no search. Now, is that only talking about federal agencies, the alphabet soup, or is that also crossing the line dealing with state agencies?
Excellent question. It is actually restricting only the federal government. Our Bill of Rights, other than what the 9th and 10th Amendments speak about, really only restrict our federal government. Most states, however, including the state of Maryland has a stronger Fourth Amendment than the federal. Okay. Most states in their Bill of Rights have statements that are at least equal to or even greater than the federal, because I love the way Maryland's Bill of Rights puts it, or Declaration of Rights, because it makes it very apparent that that the violations we see going on daily are illegal. But the police don't study the fourth, they don't study the Maryland Constitution or the U.S. Constitution to know what those limits are.
Okay.
Yeah.
And actually, I have one other question. What happens in an instant where the state is actually the violator of the rights? In my mind,
Yes.
the federal government always served as a grandfather that you can go to when your rights are being violated by the state. But it seems like that's not necessarily the case. Could you clear up that?
Let me just give you a real brief synopsis of Michael's lecture on interposition, because he shows in that every level of government, each of those people take an oath to uphold the U.S. Constitution, and therefore they have an obligation. If the state is violating your rights, your county government should be interposing against that state violator and saying, sorry, you're not going to get away with that. So, for example, Carroll County, Michael and I were privileged to speak at an event where they were issuing a resolution saying O'Malley's anti-Second Amendment legislation is not going to be regarded as law within Carroll County. In fact, the state of Maryland made something even worse than, so the violations of the Second Amendment that are happening at the federal level and the state level, Carroll County was declaring not in our territory. Now, they couldn't control what the state does or what the feds do, but they could control Carroll County and what happens within Carroll County. And the sheriff was there, and he sided with it, and the state attorney sided with it, and the commissioners of Carroll County. So they formed a group together that said, hey, not in Carroll County, we're not going to allow the violations to take place. But you're right, the other levels could intervene, but generally it's your most local government that will be most likely to protect and defend your God-given rights, because they know they're close to you, and you can vote them out of office pretty easily, as contrast voting a senator out of office in Washington, D.C. But those other jurisdictions can enter in and say, hey, this is a violation. You cannot proceed with that. However, generally what we see is the opposite. Federal government is not protecting anybody these days. The federal government is pushing a tyrannical regime on the states that are then pushing that tyrannical regime down to their counties. And we're down at the level where if anything's going to happen in America today, I believe it's going to happen at the county level of saying, no, those are unconstitutional acts. We're not going to allow that to happen in our county. Michael, you had a comment. Okay, go ahead, Frank.
This is why it's so important as a voter to pay attention to local politics, because all politics begins at local level. Those people don't get into the offices, federal offices, until they've taken 2 or 3 steps prior to that.
Right.
At least most don't. Of course, we have someone in the White House that did, but that's a whole other story. So it's imperative, and it's a shame because so many people on the local level don't vote.
That's right. Yeah, they only go out for the presidential election.
Right,
Local
and yet
races
they vote
consider.
for on the federal level, which they even know less about.
Yeah.
So anyway, vote for Mike.
That's right. If you're District 5, or if you're in Anne Arundel County, Sheriff Joe is a sheriff who will defend the Second Amendment. I'm not giving a political commercial here. I'm just stating the reality. The current sheriff in Anne Arundel County was asked the question, I believe you asked the question of him, what are you going to do about O'Malley's unconstitutional, that is, violations of the Second Amendment? O'Malley signed this bill that violates the Second Amendment. What are you going to do about it? And the sheriff's response was, I don't get to pick which laws I enforce. Oh, so if it's throw the Jews in the oven, you don't get to pick which laws you enforce. Throw the Jews in the oven. That's what we're reduced to. And so that's why I'm working for seeing a true constitutional sheriff elected here in Anne Arundel County.
Funny you should say that, because I had a similar conversation with the sheriff, and his response was he has to be careful because it's a charter county, and that if he butts them too much, will not get his funds.
Oh, it's all about his money. Okay. Okay. Right. He needs money. Yeah. Jeff.
Speaking prior to taking this course, coming into it as an average American, ignorant of the Bill of Rights and the Constitution largely, but privileged to be now midway at least through hopefully graduating and becoming enlightened and knowledgeable. Michael was talking about how Supreme Court or court rulings, the individuals stop just short of saying they are God, but on the other hand, they act like they're God with a little g. Yeah. And so that, to me, speaks very loudly. And in terms of the terror within our country, that we ought to be feeling that kind of pressure of terrorization or tyranny from our government officials. That's my observation as an average American. Now, in trying to put a finger on why it is the way it is, and this tonight was really good, I think about, Michael mentioned Amendments 11 through 27 largely created violations or breaches in the walls or the boundaries, which could be one thing to put your finger on as to how a lot of the good things that were laid out were undone. And then we think about the tests in 1971 and 1972, the Lemon Test and the Yoder Test, which basically gave the Supreme Court or the courts of the land the ability to act as God and judge and juror and all that, and executioner if so they feel inclined to be. And you mentioned FDR as a third thing. So, to me, this is helpful to kind of put things in perspective. Couldn't put your finger on, but you live in a land where the governing authorities act like they are God and stop just short of saying we are God. They might as well say that. FDR, and so those three. So maybe it's a comment, but also maybe it's a question to try to put those in some relative order, if you will, of the unraveling of our law and order society that the Constitution was meant to implement.
Do you want to take a stab at that, Michael, or?
Well, the first blush answer is you can put them in chronological order. Just what happened before what. I would also, if you're trying to put them in order, obviously the Supreme Court cases we're talking about were 1970s. Obviously, FDR was in 1940s, 1930s, and 1940s. But you could go back to the 1860s and talk about the fact that there was we've been sold a history of the war between the states, that it was all about slavery, and I could go on for the next 20 minutes to tell you how that's not true. It just wasn't. But if you accept the fact that it wasn't, what came out of it was a huge centralization of power. If you think about it this way, we all know about Pickett's charge at Gettysburg. Well, when those men went across that field in Gettysburg and they didn't succeed, the war then wound down for another couple of years. But basically, that force of Lee's men at Gettysburg was standing against all of this central authority, and I think they understood it better than we do. I think they had a vision, because they weren't fighting to preserve slavery. I mean that even Lincoln said that wasn't the case. They were fighting because they wanted self-determination and an ability to not be burdened by the what they consider to be matters of principle and substance, an overwhelming yoke that Washington D.C. was becoming. So they fought against that. When they lost that was a temporal, as I say, an earthly force that stood against what eventually happened, and so that's certainly a watershed moment too. That's something to put your finger on too. Nowadays, I mean, and I've been attacked lately for even being associated with the concept of secession. But secession is what the Declaration of Independence is all about, and secession is a historical fact. Secession is what people do when they've tried to petition, they've tried to assemble, they've tried to redress grievances, then they've tried to nullify, then they've tried to interpose, and all of that didn't work, and they leave. They try to leave. So this last week, the people in Scotland just voted on the same thing.
Yeah.
It's not a, it's not just limited to what happened in 1861. That was just an example of people trying to leave. So when this gets overbearing and oppressive, those steps come into play. Whether you and I like it or not, people want to be free. They yearn to be free. They have, we understand that they have a God-given right to self-determine. And I don't know. I got off maybe on this, but that's certainly another watershed moment in this revolution that happened from there to there. I think Roosevelt's words. I wrote down Roosevelt Revolution. That was his manifesto, and it's amazing how Obamacare and the violations of the Fourth Amendment, all these other security things, and all the endless wars for wars for empire, all have grown out of that.
And I would add to that what we see is a failure in true civics education. That at the beginning of the 20th century, the average person knew more about the Constitution than anybody from 1950 on knew. So the declining education in our understanding of the Declaration of Independence, the Constitution, the Bill of Rights, the declining education in that meant that tyrants could get away with violating the Constitution because people didn't know the standard any longer. And they say, well, I guess if those guys wearing black robes up there say it's fine, it must be fine. Who are we to question them? And so as the education level declined in terms of citizens' knowledge of these founding documents, then tyranny could prevail. And that's what we're about at Institute on the Constitution. We know this, we got, like I said, it's 150 years to get where we're at. It's going to take us time, and it may take several generations or maybe 2 generations to return, but it's got to be rooted in an understanding of these founding documents.
With all respect, or maybe not.
Or maybe not.
It'll happen quickly.
Maybe it could. Maybe people will finally get to a point where they said, enough! We're not going to take it anymore, and throw up the windows and yell out in the streets or whatever, if you've seen that movie. Any other comments or questions? This is great, but I know we've kept you guys a little bit longer than usual. If not, let's stand and close in prayer. And then you can make an announcement for everyone that's online. Thanks. God our Father, we thank you that you are just, holy, and righteous, and your standard, when it's followed by a wise civil government, will produce liberty in the lives of those under that system. We know that our founders understood that, and they followed your law and sought to, as best they could, implement a system that would preserve the God-given rights of each of the people in society. We desire to see a restoration of that, Father. I pray that you'd use each one of us in encounters we have with people that we know, and family and friends and people at church, just in conversations where we can take what we have learned and share that with others so that we can begin the restoration in our circle of influence. We can see America restored to the true land of the free based upon your holy law. And we ask these things in Christ's blessed name. Amen.
All right, as we all wrap up, thank you for joining us for Lecture 8 and 9. Remember, next week is 10 and 11, and the following Monday, October 13th, will be graduation. And if you haven't got your tickets yet for the Ken Ham event, I encourage you to do that. This week's ticket pricing is the last 2 days that you'll get the introductory ticket rate. So thank you, God bless you, and pay attention to your emails. We'll be sending out today's lecture and that as well, along with the homework. Thank you.
Until I come again, I would have told you if it were not so. Your heart must not be troubled ere I go. I am the truth and the life. I am the way. The Father has drawn